Me today. I'm going to be sharing a bit with you guys about some basic patent knowledge. Patent 101, that's what I call it, for entrepreneurs and startups. So maybe as just a way of, oops, let me just make sure I got this to work. Okay, just a brief introduction for those of you who might not know who I am. So Chris told you I work at Eagle IP, which you can see at the bottom of the screen here. That's where I work now. My background in history, my background, I actually was trained in science. So I studied chemistry at MIT, and then went to law school in Boston, the United States, at Suffolk Law. So as a patent attorney, this is pretty common, is that you have a background in science or engineering and then you switch. So I worked as a scientist, a medicinal chemist in a pharmaceutical company called Millennium, which is now Takeda Oncology, and then also worked as a patent attorney at Vertex Pharmaceuticals, which is in the United States, and Excella, which is a startup. So I've kind of done a mixture of working as a researcher, working at a large company as a patent attorney, and then working at a startup as a patent attorney as well. And then in 2017, I moved to Hong Kong. So I've been here for almost 5 years, I guess 4 years at this point. And I've been working with Eagle IP, where we, help lots of people with different types of patent issues, help them file patents in China or in the United States. So I'm a US patent attorney by training, and then our firm does both. So I can talk pretty clearly about both China and US patent law, even though I am trained as a US patent attorney. So that's my background, just to let you know who I am. So let's think about, why do you think somebody wants to get a patent? I'd love to hear your thoughts. If you want to put it in the chat box, you can. Just, why would you get a patent? What are your thoughts? Yes, to protect your inventions. Okay, thank you, Rocky. Any others? Why get a patent? And protect is a pretty, the word could mean a lot of things. So what does protecting mean? Any other ideas? Why would you get a patent? To show innovativeness. Okay, that's true. Patents are used to protect innovations. Ah, yes, sell for money. You can sell patents for a lot of money. Thank you, AutoSafe Isaac Dove. You guys hear me? Any more?
No. Someone say.
All right, I'm going to try to use this computer. Let me know if you can hear me.
Yeah, we can hear you.
It's okay?
Yeah.
Let me just double check.
Hello.
Yes, can you hear me?
Yeah, we can hear you.
Okay, perfect. Okay, I just want to make sure. All right, any other thoughts on the, well, I think you guys have hit on a lot of these. Let me reshare screen, because my other computer has crashed. So thankfully I have a backup here. Can you guys see this?
It's loading. Yeah.
Okay, perfect. So.
Someone mentioned that to avoid other use our brand or logo or product model and
okay.
copy. Yeah.
Thank you. Oh, this is a funny font on this computer. Yes, it is an asset that you can sell. You can invest in over time, so you can sell it. Raise money from investors, maybe get licensing fees. Some people will say, ensure I have freedom to operate. I'm going to explain why that's not quite accurate, but we can get there later. These are just common answers that people give. Some people just want to write pending patents on their product. Some people think it looks good on their college application or on their resume. Maybe establish that they invented something before they, collaborate with someone else. So these are just some common answers people might give, and I'll talk a little bit more in detail about all those things as we go forward. Okay, so if you guys can hear me fine, I'm not going to switch back to my other computer has rebooted, but I'll just stay on this one. Is that okay, Chris, you think?
We can see the screen, we can see you, and we can hear you. It's okay. Thank you.
It's okay? Yes, okay, then I'll just stay on this computer because it seems a bit more stable. Maybe I'll turn down the light. It seems like I'm super bright on this light. I don't think I even need this light, maybe.
Thank you.
It off. Okay, I think this is fine. Okay, sorry about the little glitch. I was afraid it would happen. That's why I set up the backup and it happened. So, all right, let me move on.
Okay, so thank you all for your thoughts on, why you think we might want to get an IP. So let's get a little bit more granular and talk about different kinds of IP, because I heard at least some of these answers are mixing different types of IP, and we'll talk through patents specifically, and this is just the agenda of what we're going to talk about today. So, okay, so I think before we dig deep into patents, I want to explain that there's actually different kinds of IP, and they protect different areas of things. So first, let's talk about trade secrets. Trade secrets are essentially what it says it is. It's a secret. They're protected by keeping it secret. So if you, like Coca-Cola has a formula, nobody knows what it is. And as long as you can keep it secret, nobody can copy it because they don't know it. And this kind of protection can last forever. As long as you're able to successfully keep it secret and nobody can figure it out, you have protection that goes on forever. So this is a way of protecting your invention. Some people have inventions that they can successfully hide and nobody can reverse engineer it. Of course, a lot of inventions, once you start selling it, people can tell how it works. So they can open it up, they can figure out, they can reverse engineer. So a better way to protect a technology like that would be through patents. So patents are for protecting technology. They're for protecting inventions that have some practical use to them. So essentially, they protect ideas, ideas that work and help society. So that's just the basic, I guess, description of what patents protect. It's innovations. They protect technology. Copyrights actually prevent from copying, and that's why they're called copying. They actually copy what we call expressions of ideas, not the idea itself. What do I mean by that? I mean that if I thought of a storyline, a general storyline of, a boy and a girl fall in love, and then they can't be together, and, they eventually do some, split up or something, that is a storyline, which maybe somebody could take a similar storyline and write another version of it. So if I wrote a story and I have certain characters, I have certain backdrop, and I write my language in a certain way, if somebody copies my language, they're copying it. That would be violating my copyright. I have expressed my ideas on a piece of paper. Just like music, if I record a song and you copy my recording, that is literally, you're copying, you violated my copyright. But if somebody just takes my idea of the story and they write their own story of a boy and a girl who fall in love and do something, then it's arguable if there's a copyright violation. Copyright is really protecting expressions of idea that have been fixed on a tangible medium and you copy it onto another tangible medium. So I make photocopies, or I copy your music onto a disk drive and I email it to my friends. I'm making copies of it. So that is a copyright violation. What is a trademark? A trademark protects a brand, for example. It is actually protecting a person's mental association with a particular mark, or let's say it's a logo or a word, with its source, meaning the company. So if I see the double M of a trademark, I might think, oh, that stands for McDonald's. And McDonald's makes high quality burgers that aren't that expensive, or they have consistent products around the world. If I go to McDonald's, I know that the French fries will taste like this. So you're not protecting against like copying per se. That will be a copyright violation. You're protecting against someone using your mark to say that I'm McDonald's when they're actually not McDonald's. So they're lying. They're lying, and the consumer who sees the M is going to think, oh, that burger is from McDonald's. It means it's a certain quality. But if someone has stolen your trademark, they are stealing that mental association so that somebody tries the burger and it's not McDonald's because it's a copier, it's a fake. Then in that sense, they have violated the consumer sort of association of that brand and what it stands for, the quality that it stands for. So again, these are different types of protections that protect different things. You could have a product, let's say, I don't know, a cup, and the cup says Starbucks on it. And it also has, let's say some words, coffee that is good for the soul, something like that. And then also, let's say there's technology that the cup keeps your drink warm. That same cup can be protected in multiple ways. The technology to keep the cup warm is the innovative technological idea that we would file a patent on. Let's say that somebody, you don't want them to copy the exact words that I wrote, Starbucks is the good for the soul. That if they copied it, they would be violating your copyright. And if they use the name Starbucks and then somebody picks up that cup and thinks that the coffee inside is going to taste like, latte macchiato just from Starbucks, but then it's a fake, now they've violated your trademark. So the same product can have different kinds of IP, and you have to file for the right IP depending on what you want to protect. There's other types of protections, like plant varieties can be protected. I won't talk too much about that. The design, if my Starbucks cup had a certain design that was not related to its utility, which would be patent type of protection, but just it's pretty, it's a design, then you can also protect your design with a design patent. And domain names are just another type of IP that's kind of important because anyone can squat a domain name. So if I do make a company called McDonald's, but then I don't file and register my domain name, then somebody else could steal it, and there's nothing I can do about that. So those are just a basic background on the types of IP. But today we're going to talk about patents because that is the focus of this talk. So this sounds like a really basic question, but actually I think many people don't understand the fundamental purpose behind a patent. Why do we even have patents as a system? So patents were created to encourage people to share their ideas with the public in exchange for 20 years of exclusivity. Now, why would it be like that? So imagine if you had an invention and you want to sell it. Now, you would be incentivized not to tell people how to make it, not to give them the instructions for how to, use it and make it, because then they would copy it, right? And they would start selling it, and you want to be the only people who sell it because you were the one that invented it. So the way you get around that is the government will tell you, please tell everyone how to make your product, because if everyone just hides what they're inventing, then nobody's going to learn from each other, and then the progress of society will actually be slower. So the way governments want people to encourage innovation and sharing of ideas is to tell everyone, please open up, show us how to make your invention. We promise that for 20 years, no one is allowed to sell it, no one is allowed to make stuff from it, only you can have it. You have a 20-year monopoly on your invention. Nobody can copy you. In exchange, please show the instructions, show everyone how to make it. If you share your knowledge, we'll learn from it and let you make money off of it for 20 years. And in 20 years, everybody will be innovating off of each other's ideas, and then society will progress faster. So that's why we have patents. That's the purpose behind it. So I explained to you, what does a patent do? Is it gives you this temporary 20-year period in which you can exclude others from making, using, or selling whatever you claim as your invention within the particular period of time, around 20 years usually, and a jurisdiction. So this is location by location. So for example, if you get a Hong Kong patent, that means only people can't use it in Hong Kong. You can stop people in Hong Kong, but it can't stop people in China, mainland China, because it's actually a different jurisdiction. You can't stop people in the United States. You can't stop people in Europe. You can't stop people in Africa. You can't stop people in Australia, anywhere else in the world. So a patent is jurisdiction by jurisdiction. If I want to stop people in the US, I have to file for a US patent. If I want to stop people in China, I have to file for a Chinese patent. One important point I'd like to point out is that a patent does not necessarily give you, the patent owner, the right to make, use, or sell your invention. Now that sounds kind of strange because most people believe, oh, I need to get a patent so that I have the right to use the invention. I told you what the law says. The law literally says a patent gives you the right to stop others. It never says that you yourself can practice. And how can this be true? It's because patents can sometimes overlap in their scope. Two people could have patents that are actually overlapping. They're not the same, but they're overlapping. In that particular situation, if there's an invention that falls within the scope of both patents, then both parties have to ask each other for permission. They have to get cross licenses in order to practice, because all a patent does is stop others from practicing. they could stop you if they have a patent as well. It doesn't give rights ever to practice, only to stop others. So that's important, and it's a nuance that a lot of people don't understand. Essentially, we have these two terms we use in patent law. One is patentability, can you get a patent? And the other is freedom to operate. Can you operate where there's no patents that can stop you? And having of course, if your patent is, covering what you're doing, you would never sue yourself. So you technically don't have freedom to operate within your own patent, but you won't sue yourself, so you do have freedom to operate. But if the person that owns a patent that's covering what you do is a competitor, then they could potentially sue you. And like I mentioned earlier, sometimes patents can overlap in scope. Okay, so that's the basics of the background fundamental concepts of patents. How do you get a patent? There's a lot of requirements that you need to meet before a government is willing to give you a patent. So I'm going to talk about two main issues. One is that only certain types of things are allowed to be patented. So there might be technological innovations that are amazing, but for policy reasons, the government has said, it's too bad, even though this thing is really cool, you can't patent it. So first, you have to make sure your invention is allowed to be patented. We call that patent eligible subject matter. Secondly, you must make sure that what we call patentability requirements is that it's innovative, it's new, no one else has thought of it before. Second is that it's inventive, so it's not obvious. You can't just take someone's invention and change like one little thing and say, I have a new invention. It's literally novel because I changed one little thing. It's still obvious and they still won't give you a patent. They want innovative technology, innovative inventions. And then thirdly, it has to be well described and enabled. And this is talking about the patent application itself. The application, you have to give those instructions, right? I told you earlier, the government is giving you a 20-year monopoly in exchange for you sharing the secrets of how to make and use your invention. So you must be clear when you draft your patent application. This is how you make it. Here are the instructions. And if you follow my instructions, I promise it will work. I'm not going to put fake instructions so that when you try to make it, it won't work because you're actually hiding the best. That doesn't work. You must show, proper and true and truthful disclosure about how to make and use your invention. Otherwise, it's not a valid patent. It's not patentable. So those are the basic requirements. So here's the statute that talks about eligibility. So I'm going to go back and just give a little more detail about what is allowed to be patented and what is not. So this you can see is the statute in the US patent law. It has to be new. I said it has to be useful. It has to do something. It can't be a useless invention. It has to be useful for society. And then you can file on processes, on machines. Manufacturers are things that are manufactured, or compositions of matter. These are like new chemical compounds, for example, or any improvements of these. These can get a patent. That's what the law says. And then the judicial exceptions, the courts have gone on to define certain things they say are not patentable. One is laws of nature. If you find E equals MC squared, you discovered this new formula that describes the earth and how it, behaves. Sorry, no laws of nature are patentable. No natural phenomenon. But the reasoning behind this is you discovered something about the world. You didn't create it. You didn't invent it. It is a discovery, and you didn't invent it, so it's not a patentable invention. It's not patent eligible. Same with products of nature. And abstract ideas is the same idea, mathematical formula or just theories about such. It's just not practical application. It is not technology. It is not useful in that sense. So these have been decided by the courts that you just can't get patents on these things. Some examples, I'll go through this quickly, but if you have questions, we can talk more deeply. Examples of things that are considered natural phenomenon. Natural DNA, for example, it's like, oh, I found out this DNA in the body. You found it. Yes, you were the first to discover it. You were the first to maybe even discover that it's linked to high blood pressure or something like that. But because you didn't invent the DNA, you can't own the DNA. Same thing with, animals, for example. You can't discover a new species of a cow and you say, I own this cow now. No, you discovered it, And even if you clone it, actually, the cloned cow, you cannot own either because it's still the same as the original cow, for example. Correlations between biomarkers and diseases, because again, these are existing in nature, you just discovered it, new discovered bacteria and such. Same thing for abstract ideas. You know, if you have mathematical algorithms or formula, or even very businessy type things like a method of how to organize people, or mental steps like, oh, if I just divide this by 2 and do that. Economic principles that have to do with money and not solving actual, you know, technical problems would still not be patent eligible, even if they're really good ideas. You overcome these types of, we get these rejections sometimes for some of the inventions that we file. And the way, you know, some people do use algorithms like mathematical formulas within their invention. They maybe created a robot, the robot uses some mathematical algorithms. We can draft the claims in a way to make it patent eligible by tying it closely to the robot, because the robot is patent eligible, it is technology. But if it's just a mathematical formula, that's not good enough. So there's ways in which we can overcome some of these, you know, what I said earlier would be considered abstract idea or natural phenomenon. If we take natural products and tie them, for example, to new undiscovered properties, like, oh, if you take these 3 natural elements together, then it can form gunpowder, and you know it doesn't react this way in nature, then maybe you can still get a patent. So it really comes down to understanding the patent laws and then defining your invention in the right way to get it to be eligible. So that's the first eligibility. And then let's talk about novelty, inventiveness, and describe and enable, because I talked a little bit about each of those. So novelty, let's talk about that, because this one's very important. And some people will do certain activities where they destroy their own novelty, and then it's really sad because then they can't get a patent. You cannot get a patent if your invention is not novel. What does that mean? Novel means anywhere in the world, if somebody just searches, let's say on the internet or whatever, they will find that this invention already exists. That means on any published paper, on any blog post, on any presentation given at a conference. And sadly, most people, when they get a novelty rejection, it's because it's themselves. It's that they went out on the internet and wrote about their invention. And then later they're like, I want to file a patent. And then they file, and then it turns out that their invention, even though they were the ones that, you know, invented it, is not novel because they already told the world about it. And the whole point of patents is that you want to promote people to share about their new ideas. If you were willing to just put it on the internet for free, then there's too late, you know, they won't give you your 20 years because you already for free just disclosed it to the world. You didn't need to be given the incentive of 20 years, you know, of monopoly. So be very careful about when you disclose your inventions. Usually we tell people you need to file a patent application first, then disclose. Then at least you've filed before you've disclosed. And it's pretty strict, you know, novelty, it's based on the day you file. Once you file at the patent office, that's the day that they use. And they look before that date to see if anything was public. There is a 1-year limited grace period. If you really did mess up and you accidentally disclosed, the US patent, you know, patent law allows for some, you know, grace period for that. Within a year of that disclosure, your own disclosure may not count against you. But this is only the US. It doesn't work in places like mainland China and other countries like Europe. So it's still not that great for a global strategy, but it's better than nothing. And we do have people who've accidentally disclosed and they use this grace period because that's all they have. Obviousness is actually the problem that we encounter the most, because a lot of people, most people, when they're developing, they're sort of building on top of things that they knew from before. So there's always an argument to say, oh, this is obvious because you're just creating a better, this kind of tool. So what the examiners will do when you file a patent application, the first thing they will do is conduct a search. They always do that. They search, and now with the internet, it's so much easier. They don't have to look in the books and stuff, you know, they can just do searches, and they've got powerful software where they search based on keywords, maybe images, whatever. And then they look and they find the closest ones and they determine the differences. And then they say, would this have been predictable? Would one of skill in the art, you know, another scientist that's similar to you, looking and knowing about what was already out there, have just thought, oh yeah, of course, this is the next step. And that's basically the analysis they will always do every single time. And it's not uncommon at all to get a rejection of this kind. Basically, almost every application gets this rejection. And usually we just have to argue back and explain why it's not obvious, And this is what they're going to say. They're going to say, oh, look, the prior one, if you tick all the pieces of this product, and this product, you'll come to your invention. It is an obvious combination of products. So you just substituted one for the other. And everyone knew because it was obvious to try. It's really bad if somebody wrote a paper and suggested trying your invention and you just did it. Then they'd be like, well, that's obvious. This professor already wrote about it in his paper. You just did what he told you to do. That's not, is that obvious? Of course it's obvious. So the way we get around that is, of course, we show that our invention is acting in a way that's not predictable. Maybe people have said, oh, that will never work, but you've shown it works. Or maybe the professor said, if you do this, then it'll be twice as good, but you've shown that it's 5 times as good. So anything to show that people wouldn't have believed that it worked or that it was better than expected are golden to a patent attorney's ears. And we love getting data like that because then we can help argue that this invention is not obvious and that is an important threshold to overcome. Finally, as I said, your application has to be drafted clearly. You have to show how to make and use the invention. You have to be enabled, meaning that a scientist of your level can just run the experiment and they don't have to do lots of experimentation to get it to work. So this really helps define a lot of how you draft these types of sections of the application. I have a whole nother seminar about how to draft good applications that we'll go a little bit more into detail about what that means. But just in short, essentially, you may not have to write out every step if most people in the field would understand that when you say something like, run a column, for example, using the solvent combination. As a chemist, most people, when they see run a column, they know what that means. You may not have to say step 1, step 2, step 3, pour the sand, pour the solvent, wait 5 seconds, because most people know. So that standard will depend on the technology about how detailed you need to be. But just imagine that you're writing it so that somebody can repeat it. That's really the standard. All right, so just briefly, these are the parts of a patent application. If you want to look at one, there's always a title, an abstract. The description is where you just explain how to make and use your invention. You can put drawings, of course. And then the claims, which are the most important part. I will talk about that part separately. Usually we submit it to the patent office for review. And, they take anywhere between, let's say, 3-4 months to a year to get back to you, usually. And usually it's with some kind of rejections about what issues the patent application has. Usually there's about 1 to 2 rounds where they will issue a rejection and then we have to respond and fix things sometimes or give up position because our claims are too broad and they're not novel. So then we have to cut back and say, okay, I don't claim so much, I'll claim less. And that takes about 1 to 2 rounds. And usually within about 2 to 3 years, you'll get a patent. You can pay for fast track and try to get it within a year, but that'll cost some extra fees because you're jumping the line. And in the US, who can file a patent application? Actually, of course, a registered patent agent or attorney like myself could file it on your behalf, or inventors can actually file it themselves into the system. They can, if they want to represent themselves, they can. The US patent law is very friendly in helping inventors to not have to hire patent counsel because it's expensive. But to be perfectly honest with you, I wouldn't recommend it because most inventors don't know what they're doing, and the arguments they write are very damaging to themselves. I've seen it done enough times, especially if it's people with a scientific training. They think differently and they don't know how to protect themselves when they make these arguments. So it can be quite damaging to themselves. But at least the USPTO allows you to do that. So I wanted to at least let you know that. Here's just I won't go through this in detail at all, but there's many different timelines actually when you start filing patent applications, especially if you want to file globally. There's different tools you can use, what's called a PCT application. Maybe some of you have heard that. It's like a worldwide application. It allows you to file into many countries around the world, and they all have their own deadlines for when things publish, when you can file divisionals, when you enter different countries. I will not go into detail on this unless if you really are interested, but we take care of this for you. Of course, if you file a patent application, we'll just tell you, here's the deadline, you need to do this next. But this is just to give you a sense of a pretty simple example of, of what one could look like. Okay, so let's say you went through all that, you've established novelty, inventiveness, you wrote your application in a really good way, and you get a granted patent. What can you do with the patent? We talked about why do you want a patent? Well, you can sue others. You can sue others to stop them from practicing your invention, sue your competitors, sue other people. maybe you don't want to sue, but you want to tell people that you could sue them. So then you just use it as a leveraging tool in a negotiation for maybe, oh, this is how much our company is worth because we have patents, you know, or you can license to others and then they can pay a licensing fee, people that want to use your technology, like that's pretty cool. Or you can even use it for marketing purposes. I wrote earlier in the examples of why would you want a patent? Some people just want to say, oh, I'm selling this amazing face cream that's covered by patent number, whatever. We use high technology that will, you know, take away your wrinkles, something like that. So even just for marketing, they might not have even gotten a patent. Maybe they just wrote patent pending. So you can have anyone can get a patent pending. You just file the patent and just let it pending. It never gets granted because maybe it's not such a good invention. But some people just want to show that there's a patent pending and it feels like it's a technological product, you know? So people have different reasons for getting patents, and depending on what reason you have, there's a different strategy for how you would pursue and how much money to spend on it, actually. So let's talk about the claims. The claims are the most important part of a patent because the claims define the boundaries of your protection, the scope of what is my invention and what can't you touch, essentially. What an infringer must not get near, otherwise you can sue them. So the claims determine the boundaries, both literally and purposely, meaning sometimes the courts are a little flexible. If the language literally doesn't cover it, but it's so close that everybody knows that it's just a technicality, you may be able to still overcome that. Courts can be quite kind in that way. So claim scope is important. So here's an example. If your invention has 3 features, feature A, feature B, and feature C, and you wrote in your claims, I claim a machine that has feature A and feature B and feature C. What does that mean? That means that somebody, if they're going to be infringing, their product has to have all 3 features. It has to have features A, B, and C. If your feature only has 2 of them, you know, like B and C, they don't fall within the scope of your patent. Your patent says, my invention is features A, B, and C. Okay, so claim scope is important. So of course, let's imagine this is the landscape of the world, right? You are the smiley face, and then we've got eyes. I stands for infringers. These are your competitors. They're the ones that might be copying your stuff, or they have products on the market already. And the distance from you is how close their product is to you, okay? There's a term called prior art. I told you earlier that if an invention is not novel, you can't get it. So what the examiner is going to do is they're going to search for what we call prior art. It means anything that was prior to you, it's prior art. It means if it's the same as your invention, then you're not novel over the prior art. So the prior art is a body of knowledge of everything that's published in the world at the time of your filing. So what I've put here is little prior art. You know, you've got publications, papers, you know, journal articles, blog posts that talk about stuff that kind of looks like your product, but not quite the same. So I put that on the map. So, you know, what strategy? How should you draft your claims? You're like, well, I want to make sure I cover all the infringers. So I need to make a very big circle. So you define your invention very broadly. You just say, oh, it is just a tool having, let's say it's like a fork. You're like, well, it's a tool with a handle and some spokes and it's used for eating, something like that. Well, the problem is spoons were already known at the time, and it also has a handle. Okay, sorry, let's pretend I didn't say spokes. I'm trying to make it really broad. I say, oh, it has a handle, it's made out of metal, and you use it for eating. Well, the problem is spoons were already known, and that covers spoons as well. So the examiner is going to reject your patent and say, well, that's not novel. You know, metal utensils with a handle and made out of metal that you eat with is already known. Look at the spoon, and you're like, oh, crap, that's true. Okay, fine. So then you're like, all right, fine. I'm going to claim a fork, you know, a metal utensil with 4 spokes made out of, you know, aluminum, and it's only 4 inches long, something like that. Well, great. So of course, now you're very far away from the spoons, but the problem is somebody makes a fork that's 5 inches long, you know, one of the infringers off to the side, and it's because you defined your claims too narrowly. You didn't cover all the potential infringers, like the forks that are 5 inches long. So ideally, you would know what the prior art is, and then you would adjust and write your claim in a way that is different from all of the previous known technologies that are similar to yours, but still can cover as many of those people who will copy you as much as possible. And this is an exercise where we can go back and forth with you. We work with you and say, okay, what's known, what's not known? Who do you think might copy you? What would they be doing? And then we craft claims in that way. And that's why the way the claims are drafted is by far the most important part of a patent. The claims are super important. So that's the claims. And it really defines, once there's an infringement and you're going to sue someone, they're going to read your claims and they're going to look to see if they have features A, B, C, and D. That's exactly the analysis that every court is going to go through during an infringement proceeding. All right, so now I want to talk a bit about how do you plan for and build a strategic IP portfolio. If you are a startup company and you have a core technology, are you just going to file one patent? Ideally not. Ideally, you would have a portfolio. And I talked to you earlier about all the different kinds of IP. Ideally, you would have a very nice, well-rounded strategy for, well, I want to protect my product. Let's protect our brand. Let's think about what can be a trade secret. Let's think about what we need to protect with copyright. And the technology, let's protect it from multiple angles. So people can't just copy, we only have one patent. Let's think about what aspects of this technology can be protected by patents. And then there's all these questions like what, when, and where, and how in order to lay out a strategy. So I'll talk briefly about the factors to think about, and then we can talk about the overall strategy. So the first one is why? Why do you want a patent, right? We gave up all those reasons earlier. This will impact a lot of things. So maybe you really want to sue other people, enforce it against competitors. That means you need a very strong patent that has lots of details and maybe examples, and the claims are really tight. So you think really hard about the claims because you're actually going to use this patent and they're going to attack your patent if you're going to try to use it against them. So it needs to be really strong. Maybe you just need the patent to defend yourself. So then that's a different strategy. Maybe you want to license it to others. So then you want to think about who your licensees might be and then draft your claims so that it would be useful to them or it would cover what they're doing, depending on how you see it. And then finally, for marketing, what if you literally don't care about the quality of the patent? You just want to put patent pending, or you wanted to do it for it to look good on your resume, So in that sense, maybe you wouldn't spend so much money and efforts to make the patent super strong because your whole purpose is just to have a patent pending and you just need it to be published and people can see it. You're never going to use it. It doesn't have to stand up in court, for example. So these would be the reasons that you have to think through. So let's think about timeline, because I told you the timeline that once you file, it takes about 2-3 years to get a patent, right? I also told you that certain activities, such as publishing in a newspaper or a journal article, can hurt your patent. So really the timeline comes down to balancing all of these different dates. Here's just an example of one type of timing that you could do. You could say, okay, I have an invention. It's a pretty good idea. Let me file on it because I know that someone's going to publish a newspaper article about us in about 6 months because we're trying to get ourselves out there. So let's file first so that when the newspaper article comes out, this won't be counted against us because it will not be considered prior art. So you file that, but you continue to do R&D, and then you have more interest, so much information that you would like to publish in a scientific journal, or maybe you're collaborating with a professor and he's telling you, I want to publish. Well, in that case, then before the publication, you say, well, let's put all of that data into a second application to make sure that, before the publication publishes, we file the patent application on the invention within that publication. Let's say later on, that there's investors for your for your startup, and they want to invest a lot of money, but they want to see everything. And you're going to share with them a lot of information. Maybe you want to file something before then. A, so that you make sure that you have protected it before you show anybody. And B, you can show them you have patents because investors love patents, right? Patent applications. So another reason in terms of timing, you think about when you might see investors and when you might want to have some timing. And similarly, if there's a product demo at a conference, that's a public disclosure. You want to make sure you file on all of that stuff before you actually go out into public. And then, when your product launch is going to be, so you might want to count backwards and make sure that you file your applications in the right countries before you start selling there. Because the minute you start selling is when people are going to start copying you. And that's when you want to make sure you have your patent granted so you can sue them. So these are all the things to consider. Everyone's story is a little bit different. So everyone's going to do a slightly different analysis on how am I going to, do this portfolio. Let me turn on the light here because it's getting a little dark now, the sun's setting. Okay, so that's the first question, right? The timeline. Let's talk about where are certain things happening? Where should I file? I told you that patents are jurisdiction related. So no matter where you are, it's going to impact that. So if you're making it somewhere, let's say you're manufacturing it in, a lot of people manufacture in mainland China, right? Then it makes a lot of sense that you want to make sure there's no people copying there. Where are you selling it to? A lot of people sell to the US. Of course, we're selling in Hong Kong probably. So then you want to make sure you have patents there so that you can sue people who are, buying and selling products, that's not you, where you're selling. And all these things, the strength of protection, types of protection, this will all help you determine where you want to file for patent protection. So we've asked also, where was the invention made? There's some nuances, and I won't go into detail because it can get very complicated. But depending on where you made the invention, where your inventors live, what their citizenship, may even impact the ownership rights of the IP. And a lot of these things can get very complicated if you didn't know about it before. The IP might not even be owned by who you thought owned it. You may not necessarily, so there's just, I don't have time to go into detail with that, but there are some tricky nuances there. So finally, really, when you think about this patent strategy, the most important thing is to think about the purpose, because that determines maybe how strong of an IP you're going to go after. And then the priorities, such as the timing, scope and strength of the protection needed, and then even the timeline of your R&D will determine what your overall, long-term strategy needs to be. All right, I know I'm getting out of time, so I'm just going to blow through the last few slides. These are common mistakes that people do. I will spend about 3 to 4 minutes on this section just to kind of go through it quickly because I want to leave some time for questions. Okay, common mistake number 1, always. It happens all the time. We meet people who have already disclosed it. So in general, if you're going to go public, you're going to tell someone about it, but sign a non-disclosure agreement. Sign an NDA, have them sign an NDA so they will not disclose it. And don't publicly disclose something if you think you want to protect it. File a patent application first. A very basic one is not that expensive if you just want to get something on file. You can always update it later. And this is, I talked about this already, publications. Avoid publications before you file. I won't share the story, but there are some sad, sad companies who, because of statements they made, hurt their entire patent and millions of dollars at stake. Patent filing strategy can really hurt you too. I told you your own disclosures can cause problems for your later filings. So it's very useful if you know your R&D timeline to time your filings so that they don't end up becoming your own worst prior art, which happens too often. I talked about ownership a bit. It is quite complicated. In mainland China, for example, if you work for a company and you invent, you don't own it. The company automatically owns all the inventions of the employees, for example. But in the US, it's not like that. In the US, inventors own their own IP and they have to assign it to the company. So depending on where you're even inventing, the ownership could flow a different way and you might not even realize it. So you really need to have good agreements in place if you're working with different people in different countries and different jurisdictions. It can get quite complicated. I will skip talking about inventorship because it's a whole topic in and of itself. Another common mistake is to not invest in IP. As I said, if you don't file in the beginning, then it's too late at this point. It is much more expensive to fix mistakes than it is to have thought about the strategy and just spend a little bit of, invest some resources into investing, at least making sound decisions about, am I going to file? If I'm not going to file, or if I'm going to file later, at least I know why I chose not to file. It's unfortunate when people decide just not to think about IP, and by the time they think of it, maybe an investor is asking them, they've already made a lot of mistakes along the way. So it's always smart to at least know what you're doing and know why you can't if it's because of budget. At least you've made a sound decision. Okay, so that's it. It's 6:50, exactly 10 minutes left. I'm happy to entertain questions. Thank you so much.
Thank you.